This story is pretty interesting because a warring couple has been ordered to allow their sons to watch only age-appropriate TV and movies. A court has also instructed the pair to ensure the boys wore sunscreen and hats. Now, the parents of the boys, aged 7 and 4, have been involved in a very high degree of conflict since they separated in 2010. The Federal Magistrates Court heard that the father wanted to increase the time he spent with his sons, a move resisted by their mother. She complained that he allowed them to watch movies that were too old for them. The woman also told the court the boys were not wearing enough sunscreen when they were with their father. She then complained her older son was not fed enough and stayed up too late while staying with his father. And the man, of course, who's 43, said that his former partner was being obsessive and overprotective. So you see, this, I guess, is the product of a situation where being amicable is just not possible. So let's talk to an accredited family law specialist, and it'll be interesting to get her view on this, from Tindall Gask Bentley, Wendy Barry. Wendy, how much of a precedent is this, where a court's actually had to say to a couple, these are the rules that must apply when you have your children?
Good morning, Leon. Ordinarily, the court does not get involved to this degree, and it is usual and ideal that the parents themselves attend to these basic levels of parenting themselves. I think everybody would agree it's less, it's very sad if the parents themselves can't attend to these basic levels of parenting. However, in my experience, I have had a number of matters where, unfortunately, a high degree of conflict between the parties has got in the way with the parties' ability to basically parent their children. And so in these circumstances, the court will actually step in and protect and care for the children where the parents can't.
You've expressed this beautifully, because my next obvious question is, surely even a warring couple who have nurtured children would understand the concept that their war means the casualties of that war are the very people they nurture. Do they not understand this?
Well, ordinarily, parents do understand this, and it is the case that the vast majority of parents are able to cooperatively parent their children, and indeed, most parents want the best for the children.
Yeah.
But there are circumstances that, in fact, the family court and the Federal Magistrates Court would have fewer matters by far in their lists if just these types of circumstances were not occurring.
All right. Does this, Wendy, does this create any kind of legal precedent?
Well, no, it doesn't create a legal precedent because the court always has had the jurisdiction to deal with these matters.
Yep.
What this particular case does is it highlights the scope of the court to step in and act in and protect the best interests of the children where the parents can't. It's not new. It's not precedent. It's simply the court exercising its jurisdiction and its paramount consideration to look after the best interests of the children when the people who are supposed to do that, i.e. the parents, have got to the point where they can't any longer focus on the important aspects of their separation.
Yeah. I guess lawyers like you would counsel parties to try and be as amicable as possible, lest intervention by the court becomes necessary and therefore expensive.
I can say that my colleagues and myself here at Tindall Gask Bentley, one of the first things we do is we counsel our clients that it is so important for them to remember that, these are the children of the product. They're the product of the relationship.
Yep.
The children will be part of their lives until they turn 18 and beyond. They've got 21st to go through, engagements, marriages, or, if they don't marry. There are so many family events that will occur in the future that one of the first things we do is counsel them that, these children you're going to have to parent for many, many years. The better thing to do is work cooperatively. The winners will be the children, and the children are actually they get caught in the gunfire, if you like, between these highly conflicted parties. So it is one of the first things we do as counsel clients: keep the interests of the children fair and square. Don't use them in the battle. In fact, we're required to do that, and in fact, parties are required to attend counselling somewhere like family relationship centres, or in fact, you cannot simply go off and issue proceedings. And one of the things we say is that if you have to issue proceedings, that should be an absolute last resort.
All right. Now, this is the next obvious question. The court has said the child's got to wear sunscreen, they've got to watch age-appropriate TV. What happens if, in the mum's custodial time, one of the children says, I didn't have sunscreen, or I saw this, and she says, oh, shock horror, this could trigger another round of, but you're not obeying the court, and given the acrimonious relationship of the two, is this not something that could wind them back before a judge?
Absolutely, and this is one of the things that we find in these highly conflicted matters, is that they do have a high presence in the court system.
Yep.
And the court is very aware that while ever there are matters before the court, it does not create an ideal parenting situation, because it's common sense. If the parties are aware that there is a matter presently before the court, they're constantly looking over their shoulder, and if it is highly conflicted, looking to use circumstances that they say advances their position in the court rather than at the expense of the other party.
Yeah.
So it's not desirable for children to have matters before the court. It polarizes the parties instantly.
Yes.
And it means they cannot be on the same page in respect of the children. Unless they are highly dedicated to their children and putting their children's needs first, it's not good for a family environment, even a separated family environment, for the children to feel safe and secure.
Yep.
And the court really tries to process children's matters as quickly as possible with a view to getting them out of the court system, so that family, albeit separated, has the opportunity to get on with living life and not constantly be looking for opportunities to advance their case in the court.
Wendy, thank you for explaining this so clearly. I really commend you for doing it in the way you have. That's Wendy Barry, partner in Tindall Gask Bentley